Well, before I finally sit down, I said I would answer the question about the figures in ground 4. The figures are to be found on pages 2623 and 2624 in volume 6. Thank you. I'm sorry, my lord. No, this was the mechanical and engineering design.
Right, volume 6, right?
It's probably sufficient to just to take a reference to it rather than to look at it.
I want to look at it just to make sure I understood it.
Very well.
2623.
Yes, and the 2623 shows.
Yes, I see.
Shows under 4.3.1b a small sum, which is the 400,000 rupees, referred to in ground 4 as additional.
Under
4.3.1b.
Yes, 400.
It's not in terribly logical order, but it is additional fees to Pro 5 Limited claimed as damages, and that's the small sum of 400,000 rupees only.
Yeah. That's the design.
That's the design
cost.
And then below that, you can see it's headed 5, and then there are 4.2 number references: designing and constructing the CDP claims, actual costs claimed as damages. I draw your attention to those simply because those are not the figures in ground 4. And then if you go on to page 2624, there is a further, if my computer would do it, there is a further sum under 4.4.6a, or item 2, damages due to delays for breach of contract and not undertaking CDP items, and that's the derivation of the 8 million figure that appears in ground 4. So to the
8 million?
So to the extent that I suggested that it was entirely the cost of design works, that was wrong on my part. And the 8 million figure is a consequential claim for damages due to delays for breach of contract. But you can see from the figure I said wasn't the figure in ground 4 that the cost of actually carrying out the mechanical and electrical works or the other works within the CDP element doesn't form part of the sum referred to in the ground of appeal.
What about costs of additional management for CD works, the next item? Is that not it?
That's not within the sum referred to.
How does this relate, if you just go back a little to his summary of final accounts? Well, just go back to page 2564.
2564. Yes.
Right. We see here under Mr. Jadoo, he's got the 14.131 million. That's the amount omitted for provisionals and then the small amount added back. That's a credit.
Yes.
Then he's got his own figure, 17.7.
That is the figure that I said isn't the one in the ground of appeal.
So what is that? That's
is if you...
physical work.
It's the physical work, yes.
Yeah.
Which you see on page 2623.
But maybe the next page, if you go to page 2565, the same figure there at the top has now leapt up to 28 million. So is the difference between the 17.761 million and the 28.754 million something to do with the design work?
I'm sorry, I can't answer that question, my lord.
Because if you look, there's a breakdown of that 28 million figure on the next 3 pages. That's 2566.
You're not claiming this?
No.
Perhaps it isn't.
So maybe not.
If I was arguing the whole of the final account claim, I'm sure I'd be able to answer all these questions immediately. Okay. But alas, no.
Anyway,
but they're not. I think the answer to the question that Lord Culmouth asked, which was, were we claiming the cost of the doing the work within the ground of appeal? We're not.
Design, which is 2623,
and the consequential damages for delay.
So, but anyway, it's a reasonably substantial sum.
Yes.
For claims for. Now, can you just help us on one question? Supposing we were in your favour on this point alone.
Yes.
What do we do with the award? Do we can we remit the matter to this arbitrator, or is he still around?
He is a judge of the Supreme Court of Mauritius.
Yes, I saw he was doing this in his spare time, was he?
Yes, they commonly, as I understand it, having been there a couple of times, they commonly do. They're permitted to sit as arbitrators. No, not entirely?
Yes.
Yeah, I should possibly ask Mr. Associate, but
They
my
get
understanding
remunerated privately, do they?
my understanding is yes.
They're rather
Yes.
busy, the Mauritian courts.
That's the reason why they take so long to...
Yes. The Mauritian courts are rather busy. But
They find some spare time, yes.
Sorry?
They find some spare time.
They find some spare time. Anyway, he's now a judge of the Supreme Court, so could we remit it to him?
It could be remitted to him, yes.
And could we remit it to him presumably we could, on a single point?
I see no reason why not.
Right, well, that's your submission, all right?
Yes.
Could I have one further question? Sorry.
Yes, of course.
The cost of redesign, we've got that figure. The delays weren't just a claim for the delay because of redesign, were they? There were other things as well.
That may be right, Lord. Which may be a reason to remit the matter so it can be considered possibly by the arbitrator.
I was just looking at 781 of the arbitrator's decision, that you satisfied the delays were due to MSC on account of their failure to submit a full set of drawings
yes.
at the time. It's delay to decide the number of floors to be built in the absence of an architect.
Your Lordship's quite right.
Delays
yes.
by subcontractors.
I'd forgotten that. Your Lordship's quite right. So there is plainly an issue. It's obviously my client's case that those delays relate to design delay, but matter that could be remitted.
But I mean, the findings by the arbitrator at 7.8.1 are against you on that. They're not treating any of the delay as being caused by the design.
Is that right?
What is it about?
Yes. I'm hesitating only because that appears on the face of it to be a general finding in relation to delay rather than specifically on this issue.
Well, it's all under contractor's design portion, section 7.
I suppose since he's held that there wasn't any breach in relation to the design, is that going to affect?
Well, he finds there's a breach. He finds there's a, as I've said before lunch, that he finds there's a breach, but he treats it as being, if I can put it rather oddly, not sounding in damages.
Yes, right.
Mm-hmm. Yes, thank you.
But how is? I mean, your claim doesn't segregate delay at all.
No, it doesn't.
Have we got section 4.4 of volume 2 of the technical report?
Almost certainly, because we have the whole of the record, but I'm sure someone sitting behind me can find a page reference to it in... Shall I ask
Yeah,
that?
I mean, he deals with delay in respect to the design
Volume 1,
separately in
478.
7.11.2, doesn't he? And he says 7.11.3,
Yes, yes,
MSC itself being responsible for the delays.
yes.
So what's he mean by that?
Well,
I think he means because they chose to subcontract.
I think he must do, because he says, MSC is not telling the truth when it says that some 6 months after the start of construction, CC pulled out from designing the CDP works, but he's already found that they had departed from the terms of the contract in their design. So that simply seems to be following on from what he said in the preceding paragraphs,
Well, look,
rather than be...
11.6.
Yes.
7.11.6 is the summary.
So it is
Yes.
linked up with his conclusion on the substance, if you look at 3. But obviously some delays were due to your ground, so you might have difficulty getting claim in anything like the sum you're claiming.
Well, that may be right. But obviously, as with much of this award, the arbitrator never got there because he reached some rather curious decisions in this case that somehow my clients had waived any claim for damages.
Yes. Right. Thank you very much.
Thank you.
Yes, Mr. Rivon.
Yes, my lord. If time permits and if I'm allowed by the board, I'd like to submit on 4 issues in this matter. Those are the 4 issues which I mentioned in my statement of case. And there are grounds 1 and 2, which identifies the central issue in our submission. Central issue being, was the final account of Mr. Jadou correct or not? Your Lordship will note that it is at that stage of the issuing of the certificate of final account that the issue was taken by the appellant. We will come back to that in the chronology. Now, this grounds 1 and 2, of course, include the important consideration in our submission of the effect of Article 1156, which was the points made by the appellant this morning, and then will necessarily deal with those principles, 1156, and when we deal with that, your Lordship will also notice that 1134 is of some importance, and it is of some importance because the appellant raised that point in relation to 1156. We'll see the correlation, so to speak, between those 2 articles. That would be the first point. The second point, of course, is the incomplete...
Sorry, where is 1134? Just remind me. Somewhere in...
1134 is the point which is raised by the appellant to say that...
it's number 2.
Yes, number 2.
Yeah.
And then, and the second point, if I may, I will deal in my submissions with the case of the incomplete record. And then, thirdly, the M&E works, and finally, the financing. Now, of those 4 points, the first 2 are of particular interest, being points of law. And of those 2 points...
Sorry, what was the 4th point? Just the one with...
No, I'm so sorry. The 4th point is the financing...
and the mechanical and...
That's 3.
Oh, that's 3, is it?
Yes. The
One is grounds
M&E
1 and
works.
2.
Yeah.
2 is incomplete record, 3 M&E.
Absolutely, madam. Absolutely, madam. So, and I was submitting that the first 2, essentially the first one, with its definition of 1156 and the application of that principle.
Well, we don't need to worry about 1156 and 1134, do we? Because you've accepted that in its inception, when it was made, this contract was a lump sum contract.
Absolutely, my lord.
I mean, I don't know how you ended up. How much time did this take in front of the arbitrator, arguing the contrary?
Well, before the arbitrator, and I'm going to go to the findings of the arbitrator on that matter, he deals with the matter of the 1156.
Yes, but he agonises over the question whether this is a lump sum contract for pages, and it's now agreed it's obvious it was. And I just ask, I mean, there may be some cost implications at the very least at some point. How on earth...
My lord, I agree entirely that...
How on earth did it come about that people were arguing contrary to what is obviously the position?
My lord, this came... I submit from the fact that this form, JCT contract, to which the appellate was referring to, is of course not known to the Mauritian law at all. Whereas your Lordship would, of course, know that better than we do in Mauritius. In England, in the UK, you simply go and take out a type of form of the contract, which would be a JCT 90 or JCT 80 contract or a turnkey contract, and then you would fit it in, and everybody would understand that what you were meaning from the very beginning is exactly this. Yes. Whereas that is not the case in our jurisdiction. You don't have special form, you simply have the contract.
All right.
And that was the beginning of the whole difficulty.
Let us then approach the case on the basis that it was originally a lump sum contract. How did it change?
Absolutely. This is what I'm going to submit on. But before I do that, can I draw your Lordship's attention to 2 points which arose this morning about the Code of Civil Procedure and the questions of appeal. So for that, can I briefly refer your Lordship to tab 24, which contains in the bundle of authorities the Code de Procédure Civile of Mauritius. Now, the Lordship will see when we look at Article 1027, beginning with 1027, and in particular 1027.1, that there are two ways in which you can contest the award of an arbitrator in that code. The first one is 1027.1, which says la sentence arbitrale est susceptible d'appel, à moins que, but which gives the authority, the power, and indicates clearly that one may appeal against la sentence arbitrale de award. Well, that's the first type of appeal that one, in my submission, may have regarding the award. Now, there is
the qualification about renunciation.
Absolutely, Balut. With the qualification about renunciation. But we'll come back to that in detail afterwards. Now, and then the second way of contesting the award is the one to be found at 1027.3 on the same page, which says that where the parties have renounced the appeal, lorsque suivant l'article 1027.1, les parties ont renoncé à l'appel, or they haven't reserved expressly this power in the convention, in the agreement, there is still a recours en annulation de l'acte qualifié sentence arbitrale. There is still, therefore, a capacity of the parties to ask for annulment of the sentence arbitrale. Now, one may say that in the end, the effect would be the same if A, if the appeal is allowed, and B, if the recours en annulation is... but the recours en annulation is only reserved, according to 1027.3, to the 6 instances that your Lordship may wish to see in that Article 1027.3.
It seems essentially to be procedural irregularity or,
Absolutely,
or breach of public policy.
Absolutely, madam. Yeah. So essentially, without going to those 6 points, your Lordship sees immediately that if you are under annulation, and you would be if you have no faculty to appeal, if you haven't provided that originally, then you would be able to go for an annulation only if you are within the cases which is listed as the 6 cases. So that's the point on appeal.
Yes, but with the exception of the incomplete record point,
yes.
Nothing we've heard today takes us into 10273.
Precisely, my lord. I wanted to make that clear for the simple reason that my learned friend, the appellant, has some cases, and I will endeavour to show your Lordship that those cases which he has submitted it relates only to instances under 1027.3. Now, why is this important in my submission is if we turn to the page and we look at 1027.4, one sees that if the appeal jurisdiction is seized with an application for an annulation, and if that jurisdiction nullifies or annuls the sentence arbitrale, it is then that elle statue sur le fond dans les limites de la mission de l'arbitre.
Sorry, where are you reading from now?
I'm at 1027.4, my lord. This is the next page. I'm so sorry.
So the court decides the dispute itself.
Absolutely, my lord. So that this is the article which gives the power to the Supreme Court, therefore, which is the jurisdiction seized of the recours d'annulation, not only if it has annulled the sentence arbitrale, but as it can then statue sur le fond dans les limites de la mission de l'arbitre, which of course is completely different from the principles which are contained in, well, the instructions which one can see in 1027.1, where the simple word that is being used there is susceptible d'appel. Now, of course, if the appeal is just a general appeal, and there's no restriction, as we've seen in the contract, meaning if nothing is mentioned of which type of appeal is envisaged, then of course the normal rules follow of any appeal to the Supreme Court. And those rules, my lord, are well known. It is, you may, of course, appeal to the Supreme Court on any matter, including concerning the award of an arbitrator. And when you do, of course, you may appeal on the law, but you may only appeal on the facts, the Supreme Court of Appeal, if it is shown that the arbitrator or the lower court was plainly wrong in assessing the evidence.
Where do you get that from?
Well, I'm just saying that this is the normal. This is not in the Code de Procedure Civile, but this is the normal principle which would appear in.
This is just the normal rule about the relations between an appellate court and a finder of fact,
Absolutely.
which is that although it's a hearing de novo, the practice is that if the finding of fact was open
Yes.
to the court below,
Yes.
it's only exceptionally that will be set aside.
Yes, well, this is the point I wanted to see, because to submit, because in the morning there were some questions on how do the Supreme Court in Mauritius approach the problem of an appeal, and in several cases which have come before the board, this was the principle which was accepted and adopted in matters of appeal. So,
Now, why aren't we within 1027 paragraph 2?
now,
When, according to the distinctions drawn in Article 1027.1, the parties haven't renounced a right of appeal or have reserved expressly that possibility in the arbitration agreement, the route of appeal is only open in order to achieve a reformation of the arbitral award,
ou à son annulation.
or its annulation. Why aren't we within that?
Well, in effect, the article continues. La Cour suprême statue comme un amiable compositeur lorsque l'arbitre avait cette
Only
mission.
when the arbitrator is sitting as an amiable
Yes, yes.
compositor. So that's irrelevant.
Yes. So,
As I understand it, 10272
yes.
explains what the powers of the court are
Yeah.
in the event that it proceeds under 10271.
Absolutely.
And it can do one of two things.
Yes.
It can vary the award or it can annul it.
Absolutely, my lord. Yes. Absolutely. This is the purport of 1027.2, and I submit that 1027.2 does apply each time there is an appeal, and the Supreme Court can then.
I think this is all quite... how does that relate to 10273? Because
Well,
10271,
yes.
it's prima facie susceptible of appeal.
Yeah.
10272 is consistent with that. If you haven't renounced the right of appeal or if you've reserved it expressly,
Absolutely, my lord.
then 1072 applies.
Yeah.
But 10273
Yeah.
applies when you've renounced the appeal, I understand that, or when they haven't expressly reserved the right to appeal. But if-
Even when they haven't. So, I mean, this looks as if
or, I know, but if it,
power
if
that
it
exists anyway.
even if it's within 10272, because this overlaps with 10272.
10273, if I may, my lord, applies, first of all, when the parties did not include a right of appeal, and this is what the first
It
sentence...
applies whether they've included a right of appeal or not, doesn't it? Because if they have, for example, if you take case 1,
Yes.
it's hardly conceivable that if the arbitrator had no jurisdiction, because there was no arbitration agreement,
Yes.
that the arbitration agreement wouldn't be annulled, whether there'd been a renunciation of
Absolutely. my lord.
appeal rights or
Yeah.
not.
Your lordship is referring to 1027.3. Yes, yes, my lord. This is perfectly the case.
Anyway, the answer is, since most of the provisions are not within 3, I think it has to come within 2, and 3 doesn't seem to exclude 2.
Yes.
I mean,
yes.
the only arguably relevant one is case 3 deals with the case where the arbitrator has not fulfilled his entire
Yes.
mission. In other words, if he's left out some part of the dispute.
Absolutely. Or he's gone beyond that.
Yeah.
He's gone beyond.
Right. Well, now, to come to the point, if we concluded, just put the same, I'm putting the same question I put to Ms. Jefford, if we concluded that this award was wrong in some respect and maybe only in one respect, what are you saying we could or couldn't do? Are you saying that all we could do is, all the courts could do is decide on the substance themselves, or can they remit to the arbitrator?
My submission is if the Court of Appeal or the board, well, in our case the board, finds that the arbitrator made a mistake in law, was wrong in law, or made such a wrong appreciation of the facts as to be plainly wrong on its assessment of the facts, then the only thing that can happen in my submission is that it simply dismisses annuls the ruling of the of the arbitrator.
And does what?
And I'm just wondering whether, in my submission, whether one could remit it to the arbitrator, because then, because in truth, the arbitrator only has its powers regarding.
It must be able to. Supposing the arbitrator, because of a mistake of law, has decided he doesn't need to investigate a particular factual question.
Yes.
The court can't invent the answer to a factual question.
Absolutely.
So there must be a power to send it back to the arbitrator.
Yes, my lord.
I mean, I don't know whether arbitration is common in Mauritius. I know you've got a new act, haven't you?
No, the arbitration. No. We have two laws regarding arbitration in Mauritius. One is the one we're looking at, which is the civil procedure, and the other one is the international arbitration, which is not concerned with the arbitration, what we would call local arbitration, but arbitration with an international.
Anyway, I think you agree that there must be a power to remit.
There must be.
Yeah.
So that's the point I wanted to make, with your permission, on the point of appeal which was raised this morning. Then, may I draw your lordship's attention to the attitude of the respondent in the Supreme Court. It has been said this morning that the respondent was not very precise in approaching the question of the appeal before the Supreme Court and making it clear that, in fact, it could not be an appeal which involved reassessing the facts completely. Now, I submit that if your Lordship look at page 553, I understand it should be volume 2, what? Page 5583, I think it is. It's volume 14, my lord. 14, my lord.
553.
Yeah.
5584.
5584
Thank you.
is the page, and the volume is
So which bundle is it?
volume 14, my lord. I'm taking your lordships to page 5584, which is to be found in volume. This is the case which the respondent was making before the Supreme Court. It's entitled Respondent's Skeleton Arguments. That is the procedure in our law. And
This is your case.
absolutely, my lord. So if one looks at the following paragraphs of the skeleton arguments of the respondent, one would see at page 5584, volume 14, that we have this at paragraph 6 of 5584. The respondent is saying the question of interpretation of the contract is a question of fact, which is within the domain of the arbitrator to decide. And we cite the case of Vishnu.
Yeah.
And the appellant continues, he has rightly interpreted the contract and there is no valid reason for upsetting his findings. Then, can I take the lordship to page 5585, where addressing the, grounds 50, 61, and 64 of the appellant at that time, the respondent replies in three first paragraphs, 13, 14, and 15, the issue was a matter of evidence and of facts. Well, this issue,
That's
the
what.
learned arbitrator correctly addressed his mind to the evidence and reached the conclusion that the version of CCE was not shaken in cross-examination. And thirdly, as there was evidence, well, that is point 15, as there was evidence upon which he could rely, his findings cannot be questioned. That this, in my humble submission.
This goes to which finding? Just show us.
Well, this one
Changing
went to the
yes.
to the finding of whether the building was completely changed.
And that's quite early on in his finding.
Absolutely.
Paragraph 8, I think.
Absolutely. So
8.2 and 8.3, is it?
yeah. And then we go further to page 5590. We're still in the skeleton arguments of the respondent before the Supreme Court, and we see ground 29 being replied to in the following manner. Was there an architect on the project throughout? And the paragraph 36 concludes in those skeleton arguments that this matter was fully canvassed before the learned arbitrator, who considered as well all the documentary evidence and came to the correct conclusion, which cannot on appeal be challenged. Now, my submission, when one looks at those points, is that it's indicated that what the respondent was submitting before the appellate court was, if there is evidence which allows or allowed the arbitrator to conclude on a set of facts, then his findings cannot be challenged. So that clearly, going further than that would amount to saying that one could start de novo all matters of facts before the Supreme Court. We submit that this was not our case before the Supreme Court, and we raised that point as from the moment there was an appeal before the Supreme Court of Mauritius. I think I've done with those 2 points raised this morning. And of course, having done that in the grounds of appeal, one can see now how the Supreme Court dealt with it. And if I take your Lordship to page 5914 of the same volume, 5914 of the same volume, your Lordship will see that this is the judgment of the Supreme Court. And at page 5914, the Supreme Court, at its second paragraph on that page, in fact, it's page 16 of the judgment, but for us it's page 5914. When we go to the second paragraph of that judgment on that page, we see the Supreme Court saying, we do not agree that the arbitrator did not consider the documents referred to it by the appellant, where it was contended that there was a reference to a lump sum contract. In fact, throughout the award, the arbitrator makes it a point to mention the words lump sum, even where it was referred to by the respondent itself, which shows that the arbitrator was fully alive to the case put forward by the appellant, the evidence it relied on, so that when he came to the conclusion that he reached, regarding the type of contract that the parties finally agreed upon and that was binding on them, he did so in a considered and balanced way.
The difficulty with this is that it's wrong, isn't it? I mean, you now concede that that wasn't the agreement they entered into.
It depends what's meant by finally agreed.
Well,
No.
Unless you're embracing the variation, which they may have dealt with.
The reference is regarding the type of contract that the parties finally agreed upon.
Well,
and was binding on them. He did so in a considered and balanced way. But I agree with your Lordship that it could have been worded in a more precise.
did they deal with the variation argument anywhere?
The Supreme Court, my Lord?
Did they deal with the argument about variation expressly anywhere? Did they deal with the argument based on interim certificates or valuations?
Yes.
Where do they deal with that?
I'm just having a look at the... Can I briefly come back to that, my Lord,
I mean,
while this is being...
At this point, it seems to me, as they say higher up the page, they're probably dealing with the contract entered into.
Yeah. I should come back to that with more precision, my Lord.
I think it's at page 5920 where
Right.
one further reason given by the arbitrator to show the contract, it wasn't a lump sum, that's not variation, it was the following. He says there's no architect, they allowed all the interim certificates, and says the MSC cannot now resort to a clause which has itself by conduct never applied or indeed tacitly waived. So I think that's where they set out the arbitrator's position.
I'm much obliged with your Lordship. Your Lordship is right. And
5920?
5920.
5920.
Whereabouts on the page?
They quote the arbitrator.
Yeah.
Oh, I see. Yes,
Yes.
Right,
Yes. This is the way the
so
Supreme
it
Court
starts
dealt with it in the circumstances. So I have finished with those 3 points which was raised this
Could I
morning.
just go back to a point
Yes,
which we discussed this morning, and I'm not sure what your position is. That is the provision in the contract which gives the power a right to appeal on a point of law.
Yes.
Now, is it part of your case or not that the contract should be construed so as to conclude that the parties agreed that there would be no right of appeal on an issue of fact?
Yes.
Is that a point you're taking or not? Because that's a different point
Absolutely.
from the one you have been addressing
Yes, absolutely.
moments or two ago based on the code.
Our submission is that since the parties had agreed that there would be appeal on the question of law only, and taking into consideration that the subsequent agreement, which was signed by the parties, merely confirmed and could not be in contradiction with the points in issue, then one cannot say that the clause 6 of the subsequent agreement varied from clause 41.6, which was
This is set out in page 2 of your case.
absolutely, my lord, absolutely.
I don't think it was put in that form to the Supreme Court.
No.
You're taking it before us.
Yes, yes. I agree, my lord, that the way it's put before the board is more precise and better put than what was put before the Supreme Court.
I mean, it's sort of suggested that that you sort of waive that in some way by putting in some 60-odd grounds.
One may have that impression, my lord, or that perception, but we submit that it is a point of law and jurisdiction, and for it to be specifically renounced, there should have been more than what we see.
I mean, in this jurisdiction, it would be regarded as rather important nowadays that appeals from arbitrators are confined to issues of law and then pretty restrictedly.
Yeah.
Has that been an issue which has been considered in Mauritius at all? Or?
Yes, it has, my lord, but not in the precise way your lordship is putting it. The Supreme Court, when faced with an appeal from the arbitrator's ruling, has consistently say that if one chooses to go to arbitration, then it's no use afterwards to ask the Supreme Court to conduct the same exercise. I'm just citing from memory, but your lordship is right. The point has been taken in that way, but not directly. Not directly, because I cannot recall in my submission of a precise arbitration case which went an appeal in which this clause was included specifically. So,
you're saying it's unusual to find a JCT contract in Mauritius, are you?
my lord, my submission is that it is unusual.
I think they said they didn't know about it at all.
Yes, yes. And in fact, this was one of my submissions before the arbitrator, that the concept of something, if I be allowed to be colloquial, known as JCT contract doesn't exist. Doesn't exist. Of course, it exists.
There's no French equivalent, is there, to it?
Well, there may well be a French equivalent in France,
Yes, but not in
Mauritius. Not in Mauritius.
Do we have the case you cited before the Supreme Court of Société de Vishnu against the Union Flak Sugar Estate?
Do we have that in the tab, my lord? I don't think that we have that in the tab. No,
Because that seems to be quite relevant on the approach of the courts to arbitrators. I think maybe we ought to have a copy.
Perhaps if I can be given some time, I may perhaps quickly have a look at it. Yeah. So we have Société de Vishnu and Union Flak Sugar Estates Company Limited.
You have it?
I have it on this contraption, which they call a computer.
An Apple computer.
Yes. It's online.
It's from the Supreme Court internet.
Yeah. It's a Supreme Court site, my lord.
Oh, I see. So we can get it here.
Yeah. Oh, absolutely. I'm just giving the reference to your lordship. It's 1965 MR 245, and the judges are Sir Ramparsad Niranjan, who was the Chief Justice, and the other judge is Judge Rivalan, who the paragraph which I'm sure would be of interest.
Do we have? Can we? Yes, I see.
Yeah.
Doesn't seem to turn up if you put in Vishnu.
Yes.
Well. All right.
Okay, madam. Thank you. So So I was about, my lord, to submit on the question of 1156. And the submission of the respondent in that matter is as follows. Now, the question which arose was, did the arbitrator make a correct application of 1156 in seeing whether the conduct of the party showed that the parties chose to modify the term?
Is 1156 concerned with conduct? I thought it was only concerned with the
Intention.
interpretation of written acts.
Well, 1156 is used, in fact, in that particular case, and I'll come to the principle in a minute, to find that there has been a modification of the contract. This modification, in my submission, is shown by seeking the intention of the parties. And this intention is revealed by the performance or the conduct. It is in this way that in my submission, one should approach the application of 1156. Now, where the terms of the contract are clear and precise, when the terms of the contract are clear and precise, one cannot use 1156 to make an interpretation of those clear and precise terms. The way in which 1156 can be resorted to is to find, as in our case it is shown, a modification of the contract. So that in my submission, there is, so to speak, no use to say that when you look and try to interpret the terms, the words used of a contract, if the words and terms of that contract are clear and precise, then of course 1156 will not be of any help.
Yes, but can it not be said against you, accepting as you now do that the JCT is clearly a lump sum contract, that we don't get into 1156 at all?
Well, we wouldn't.
But we get into 1134 because your case, as I understand it, is that one can vary a contract by mutual consent.
Yes.
And it doesn't have to be express consent. It's
No, it doesn't
consent
have to be
inferred from the actings of the parties.
Absolutely, my lord. Absolutely, my
But
lord.
aren't you going a little further and saying that in deciding whether there is mutual consent, and if it's not clear that there's mutual consent, you can then look at 1156 to see what the parties intended? Or perhaps I'm over-interpreting you.
Well, the three propositions I would like to
Well, the proposition behind 1156 is that there is a convention. So you have to find some sort of agreement, don't you?
Absolutely, my lord.
And then this is dealing with its interpretation.
Yes, yes.
But your problem, the point you've got to satisfy us on, is that the arbitrator was right, or at least not wrong, in saying that there was an agreement to vary the earlier lump sum contract.
Yes.
And you're going to refer us, no doubt, to the basis on which he found that.
I will first of all indicate to your lordship the authorities in Mauritius and the authorities in France of the Cour de Cassation, which establish that principle, which in my submission is an important principle in Mauritius.
What, this principle?
Of this principle 1156, and then
it establishes itself, and I think I may speak only for myself, but it's a given that there was an agreement. You've got to show another agreement.
Absolutely, my lord, and that agreement, the French authorities say that it can be proved by any means whatsoever.
Can you just help me on? Sorry.
Yes,
as I understand it, interpretation, which is what the fifth section, including 1156, is concerned with, is a technical term in French law, which means the process of arriving at what the parties have agreed, other than the examination of the language of a written act? As I understand it, you start with the examination of the written act.
Yes.
That is not interpretation in its literal sense.
Absolutely.
That is simply reading the language to see if it is clear.
Yes.
If it is unclear, you then have resort possibly to other sources of evidence about the party's intention, and that is what is referred to technically as interpretation.
Yes.
Is that right?
Yes, absolutely. But 1156 go further in the sense that it allows the trial judge to review the subsequent behavior of the parties in order to determine what was the common intention of the parties. And
That's
that
the
intention...
common intention at the time of the original
No, my lord.
act.
No, it is the intention disclosed, revealed by the conduct of the party. If one sees there is contract A, but the parties have conducted themselves on specific matters or on all matters clearly contrary to the terms of the contract. So that...
Yes. But then you aren't interpreting, you're changing the contract.
You're varying it.
Then if, you can only do that if there is you discover a common intention of both parties to vary the first
But I
contract.
can't see that, as I understand it, 1156 and following is concerned with interpretation as a supplementary method of discovering the intention of the parties, supplementary, that is, to a written act. So that if you are trying to discover what the original intentions of the parties were by reference to their subsequent conduct, then that may be regarded as interpretation. But if, which is your case, you are trying to say that there was a second agreement to change the effect of the first, then one isn't in the domain of interpretation at all. One is simply looking at what the evidence is for the existence of that agreement, and 1156 doesn't really help.
The 1156 is a mechanism which allows a judge to review the subsequent behavior of the parties, subsequent to the first, let us say, written agreement.
Yes.
And in this sense, my lord, convention, which is being used...
Only for the purpose of discovering what the intentions originally were, and you have conceded that the original intention was that this should be a lump sum contract.
No, my lord, if I may answer that in this way, the 1156 does not serve solely to try and discover the original intention of the parties. And the example which I may wish to give is if the parties, by writing, have embarked, have signed, have accepted on contract A, and if subsequently it is observed that they have conducted themselves contrary to the contract at all, then 1156 would serve to discover what was the common intention.
Now, well, I think there is we understand the point, and I think there is a fairly fundamental point here.
It is.
Is there some authority which we would be interested to see if we were of a different view? Is there some clear authority on this point?
This is precisely what I'm coming to, my lord.
I think it may not matter, because ultimately what we're concerned with, whether it's by reference to some process of interpretation or simply in terms of variation, is whether there is a clear subsequent conduct which demonstrates that the original contract, or what would otherwise be the original contract, can't stand. So that's the point, and we need to get on to the factual aspects of that point.
That is exactly the point.
So if you've got some authorities on this point which you want to briefly give us, do.
Yes. So may I refer your lordships to 3 French cases?
Yes.
And this is the described in my paragraph 15.2 of the statement of case, your Lordship will see that at the case C, 5th of February 1971, that's one.
Sorry,
Which flag is this?
And that's tab 17.
15.2 in your case.
15.2.1, my Lord, yes, precisely.
Right. These are flag 17, the first one you said?
Tab 17, yes, my Lord.
Yep.
Tab 17. Yeah, tab 17.
Right, what's the second one and the third one?
This is the first one. The second one is tab 10, which is the case of the Commercial Division, 8th of December 1987, tab 10. And the third case is tab 11, which is the case of the 13th of December 1988.
Yeah, well, these are to do with situations where the original contract
Yes?
was obscure or ambiguous, and subsequent conduct could be looked at to throw light on what it meant, and that's particularly appropriate if there's either an oral contract or an obscure written one. But here, there's no obscurity.
Perhaps I should bring your Lordship to the three cases.
Yeah.
It's a
Well,
brief,
I think we've seen them somewhere.
brief way. Yes, but the first case on tab 17.
Can you point us to the words you rely on?
The terms there were clear and precise, and the appellant was precisely saying that, well, the terms of the contract are clear and precise, and therefore there could not be any interpretation. The ground of appeal argued before the Cour de Cassation was precisely saying that the lower court was wrong to have interpreted the terms of the contract because those terms were clear and precise and could therefore not be subjected to interpretation. Mm-hmm. And the Cour de Cassation rejected that ground of appeal, holding that it was for the judges of fact, and when I say judges of fact, in fact, the French word for it is the juge du fond, judges of fact, to look for the common intention of the contracting parties in the terms used by them, as well as any subsequent conduct which by their nature is revealing of that intention.
But that's not referring to a separate agreement to change an earlier agreement.
That's
referring to a technique for deciding what the parties' intentions were in relation to the original agreement.
That is not what the case reveals. The case reveals that the respondent, the agreement between the parties were A, and in spite of that agreement being A, the parties went to do in some respect B. Mm-hmm. And it is on that matter that the Court of Appeal pronounced itself. And the other side was saying, well, you can't do that when the agreement was clear and precise.
No, it doesn't say that. It was alleged that it was clear and precise.
Yes.
But reading the whole of the decision, it doesn't appear that the Court of Cassation thought that it was clear and precise and incapable of interpretation at all.
Tab 17, yes, my Lord.
Now, there's quite a lengthy.
It is indeed, my Lord.
Yes, well,
it is indeed, my Lord.
I know, but the gist of it is that they didn't accept that this was so clear and precise that you would be denaturing it by interpreting it.
Yep.
So, I mean, I think we've got the point. We've got your authorities, and I think there is quite a bit to get through.
Yes, my Lord. So, having gone through that, I have also filed a bit late, I'm afraid, the commentaries of Juris Classeur, and this would be in the tab which was produced to you. And I think
yes, they'll go for, yes.
Tab 3, and it's a 3-page document, and this is the first page is entitled Contrat et obligation, one can see.
Sorry, where is it? Perhaps I haven't got it.
Your Lordship will
We've got a rather
bear
plastic
with me.
extract.
That's from the appellants today.
Yes. Do we have another extract from that we should be looking at?
I don't think I've seen another
I have a
one.
short one which begins on page 379, is that right?
No, that's the...
No, not this one, my lord.
Jonathan.
Not this one.
No, I'm not sure we've got this.
Well, I have a copy which was sent to their lordships.
Oh, well done.
There's a letter that came in on the 6th of May with
Yes,
code 1011 and three code de cassation
Yes,
decisions.
yes, I'm much about your
Is
lordship.
that what you're talking
Yeah,
about?
yeah.
well, we've got that.
This is what I...
And so which page in that is
Now,
it?
one should, if one has the letter which was sent by our solicitor
Yes.
to the board, your lordship will see the first page signed by Mr. Carrington,
Right.
where one sees 1, 2, 3, 4, 5 authorities, and the fifth one.
Ah, the mega code, yes.
No, I'm so sorry. It's the juris classeur, my lord. I don't know whether in that bunch your lordship finds juris classeur. One must first find juris classeur and then.
No, it's not in that bunch.
No. There's an extract from Dalloz. It's not what you
Yes, well, I'll come back to that, but that is not the paper to which I'm referring to.
Well, I don't think we'll ever get to the end of this argument.
Can your lordship give me one? Yeah. I'm so sorry, my lord.
Additional
Yeah. But where is it?
Yeah, 10 minutes.
Yeah. Well, it's included in the bundle of authorities as a loose sheet, my lord, and it has an English translation to it. Your lordship doesn't have it. It starts by contrat et obligation, and it's the juris classeur.
That's the document immediately after the Dalloz extract.
Absolutely, my lord.
Oh, right, excellent.
Right, so that's the juris classeur, is it?
That's the juris classeur, Lord, yes. Juris classeur is like a code annoté Dalloz, only it's juris classeur.
Right, all right. Now what are we looking at?
What I would wish to draw your lordship's attention, there is 2 paragraphs. First, on the second page of that authority,
The first paragraph under point clé
Yes,
is a very succinct statement of
Yeah.
the role of interpretation.
yes, yes. Now, then we have, under méthode d'interprétation, we have this at paragraph 22. I'm just identifying the paragraphs first. Then, at paragraph 40, your lordship will note that we have the paragraph starting with méthode volonté déclarée.
Sorry, paragraph 23, did you say?
22.
22.
Paragraph
Recherche des intentions.
Yes.
22, my lord. Méthode
And you then said
d'interprétation,
you then refer us
recherche
to
des
40.
intentions. Yes.
You then refer us to 40?
Yes.
Because my extract doesn't have 40.
It's on the, it's,
No, it doesn't.
it's on the second page of...
It's on the reverse page, my lord.
Reverse page.
Oh, you don't have it?
My,
so-
my extract is only copied on the face page.
yes.
Well, on the face of it, your lordship should perhaps look at the 1, 2, 3, 4, fourth page. Where your lordship,
The trouble is, it's only been copied on alternate pages in my case.
paragraph 40, my lord.
14.
40.
40. I do not have 40 because I only the reverse of my pages has nothing on
blank.
it.
It's like the bill of quantities, my lord,
Yes.
of the respondent or the appellant, blank.
Well, I mean, I'm sure that if I had it, it would be very helpful.
Yes, can I
All right. Look,
hand over my...
We must press on, I think.
I think if this seems to all to refer to Article 1156.
They do indeed, my lord.
Yep, well, I think we can read it to ourselves probably, but
Yes, yes,
I think we've got the gist of your argument on
Yes,
Article 1156.
yeah. And
You need, I keep, Mr. Uribe, I must
Yes,
emphasise you need to develop the argument
This
on
is what I'm doing.
variation.
Yes, Lord, yes. And the argument of paragraph 40, or 41 for that matter, it says this. In the end, the meaning of 1156, and this is paragraph 41, at what is page 15 of the Juris Classeur, the meaning of 1156 is quite simple. Once it is established by any means whatsoever that there is a discrepancy between the real intention as expressed, be it tacitly, and the formulation in writing or orally of that intention, the former must prevail. This is not in contradiction with the theory of denaturation. A clause may be clear and precise, and I'm just continuing on this paragraph 41 and the end paragraph. A clause may be clear and precise in appearance only. This is precisely the case if the discrepancy mentioned above is established. There would be no justification of giving effect to what is only an appearance over what is true. Meaning that, in my submission, it means that if there is a discrepancy between what was agreed in writing and if it is established by any means whatsoever that there is a discrepancy between the real intention as expressed, then the former must prevail. And this is the reference to the signification of 1156. Then,
Right, I must remind you, Mr. Uribe, you've got a maximum of half an hour.
Yes,
we're
yes,
prepared to sit 10 minutes later,
yes.
And you've got quite a lot to get through.
Yes,
I think we've understood your argument on this aspect. All right. It may not matter in the end of the day because one way or another, you've got to establish, in your terms, either a common intent or a variation.
Yeah, I have to establish factually
You have to establish
the evidence of any modification of the contract as found by the arbitrator. Yes. I understand that, my lord. So now, and then when we look at the free Mauritian cases...
Can we not just get on to the facts?
Oh, right.
We'll read all that later. I think we should get on to the facts, if I may.
The submission on, if we have established that this is a principle of law, 1156, which allows the judge to do that, then, of course, as your lordships are suggesting, one should go to what are the facts.
Well, I think it isn't disputed that one way or another, if there was a clear common intention manifested between the parties to change what would otherwise be the meaning, that is going to be effective.
We submit, my lord, 4 points. First, the absence of architect. This was a contract which was the contract signed on the 3rd of December 1993, in which the architect played a central and prominent role. And from the very start of the starting of the execution of the works, the architect was never present. Now, it was the architect who, under that contract of the 3rd of December 1993, had the duty to issue the plans, and it is common ground that there was only, at the start of the execution of the contract, only 22 plans, and it ended up with the 400 plans, and therefore was not issued by the architect of the contract. The second point is that it was the architect who had to issue the valuation, and it is common ground that it is Mr. Jadou who, all through the construction of that building, issued valuation number 2 to number 22 for the whole proceedings of the construction, and this again was against the contract, posing there 1 minute to say that in spite of the fact that the architect was absent, both parties started the execution of the contract and finished the building without any stopping or of the contract or of the execution of the works under the pretense that they had no architect. This is the common intention shown in that extract. The issuing of the valuation is the same pattern. Although the contract of the 3rd of December 1993 provided that the only person could issue the valuation was the...
We see that, but
you see
you'll have to tell us why it matters.
It matters because it shows that both parties had the common intention to depart from the contract of the 3rd of December 1993.
Well, I know, you've got to show they had a common intention to depart from the contract so far as it was a lump sum contract. Why does it bear on that?
Well, so far as it bears on that because the valuation number 2 to number 21 was made on the basis of a measure and value method, which goes against the section 30 of the original contract, which provided at section 30.2 that and this is page 141, volume 3 of the contract. Yeah.
Yes.
Page 1141, my lord, volume 3.
So why is it against 30.2?
Well, 30.2 stipulates that the interim certificates need to be calculated by way of gross valuations, my lord.
Yes.
Yeah, and we submit that...
Why wasn't it calculated by gross valuation, which is defined as the total of the amounts referred to in 30.2.1?
Yes.
Which refers to the total value of the work properly executed and the total value of materials and goods delivered.
Yeah.
So what's inconsistent?
What we submit is that it is clear that the valuations were by way of not gross valuation, but measuring actually the work done and valuing the work done.
So you say that they accepted that by effectively paying up on that basis?
They accepted that not only by accepting that this issue and this calculation were going to be done, but by paying and sometimes even going to the length that we know that we owe you on this certificate.
Why is it inconsistent with the basic nature of the contract that you adopt an intermediate or an interim method of payment, which leads in the result to actually substantially less than the original bill of quantities or contract sum? Why is it inconsistent with the contract's nature?
The respondent submits that gross valuation does not include measure and value.
Why?
Gross valuation does not include particular valuation and precise valuation of the work done. And section 30 in my submission does not mention that you should proceed by way of measure and value.
Why? It does. If you look at 30.2.1, gross valuation, which is according to 30.2 where gross valuation is defined or referred to, it includes the following, namely the total value of the work properly executed by the contractor, etc., and under 2, the total value of materials and goods delivered to or adjacent to the works, and so on.
As I understand it, your argument is that the gross valuation of the works, if it had been carried out on a lump sum basis, would have been expressed as a proportion of the lump sum, whereas in fact it was expressed without reference to the lump sum as a value arrived at just completely independently of the contractual provision.
Speaking a bit generally, if the 10 stories to the building, and that building is worth 100 million rupees, Gross valuation means if I've done one story, then of course the valuer would say, well, I'm paying 1/10 of...
Where's the evidence of this? I mean, this doesn't find any basis in the wording here. You're adopting a point put to you, but where is the basis for it?
Well, the basis of this is simply the word gross valuation. Gross valuation means, in my submission, that valuation which is made grossly and not in details. Now, of course, before paying on...
Yeah, I don't understand this at all.
Yeah.
If you read the language, it says gross valuation shall be the total of the amounts referred to in 30.2.1 and 30.2.2, and that is defined in general terms. We were told by Miss Jefford that who was also perhaps giving some evidence as to what might be the meaning, that it's actually can be done in a variety of ways, but if you do it on a measure and value basis, it seems to correspond precisely with the language.
I mean, the language on the face of it doesn't specify how you value it. It just says there's got to be a valuation. So one would expect it to be valued in accordance with the kind of contract it was, in this case a lump sum contract.
This is what we submitted.
Right? That's the point.
Can you tell me this, was there oral evidence addressed to this point, or before the arbitrator? Was evidence given about the alleged variation or departure of the parties from the contract, or was it simply dealt with on documents?
I submit that Mr. Jadu, the sworn-in surveyor, gave evidence and referred to and referred to the manner in which he proceeded to first of all calculate the according to the measure and value method, and also the way he approached the variation in that.
Can you give us a reference to
Yes.
that?
Volume 2, page 690.
Yeah.
2690. Thanks very much.
What bothers me about all this battle about whether it was a variation or not, is that what Mr. Jadu purported to do was to prepare a final account in terms of clause 30.6 of the conditions of contract. And he says he adjusted the contract sum of 100 million rupees for the following reasons. And he explains that in relation to basement concrete and blockwork, the whole structure components have been altered, and therefore the whole scope of works have been changed. And the only method he could do to put a value on what had eventually been created compared to what had been initially contracted for was to measure it.
Yeah.
Now, what is puzzling me is how different is that from the approach that would be taken if there was a variation?
I mean, that's the point we put to Ms. Jefford, that
Yes.
Actually, when you look at Mr. Jadu's final statement, he doesn't appear to have been doing it on a pure measure and value basis at all. He's worked back from the contract sum, and her real complaint, and I'm not sure this has emerged in so far, but is actually that he omitted some credits.
Well, I'm not so sure that factually that is correct. But obviously, your lordship is right on the fact that in the end, well, one comes very near to the sum of 100 million, and that's very normal because, in fact, the details of the 100 million rupees calculated as being the lump sum of the contract was the sums of all the works which had to be done according to the BOQ. And the rate at which it was calculated.
Could I ask this question?
Yes, madam.
Was Mr. Jadu's evidence as set out on that page and the following page,
Yes.
and 2 pages, as to his methods,
Yes.
was that challenged?
Well, it was not. It was only challenged by Mr. Bowler, but after the contract, after the building had already been completed. And in a way which I'm so sorry, my lord. I'm just finishing. In a way that the arbitrator found could not be given any credit because Mr. Bowler committed 2 mistakes.
Yes, well, I don't go into Mr. Barrow's evidence, but whether or not his calculations were correct,
Yeah.
did anyone challenge the veracity of the method that he said he used in this?
Not during the 20 interim valuations that Mr. Juddu did.
Yes.
No, I don't think you get the 20 interim evaluations here. That what's being put to you is that at the end of the day, he didn't do a pure measure and value. Anyway, we've got the point.
Thank you.
So can I go quickly?
Yes,
I see the time.
you've got 2 of the 4 points you've listed.
And on that differences between what was written in the contract and the measure and value method, we have 22.1, and this is page 17 of the statement of case. Can I bring your lordship to page 17, paragraph 22.3, where one sees that on the 27th of January 1994, MSC writes to Mr. Juddu, this is in our statement of case, 22.3.1, the MSC writes to Mr. Juddu to inform the latter of the decisions taken in meetings, and that is the meeting where your lordships will find at page 5034, but I will not bring your lordships to that given the time. In that letter, this is the letter which Mr. Ajoda sends to Mr. Juddu because Mr. Juddu was absent in a meeting. And Mr. Ajoda, in that letter, writes that wanting to keep Mr. Juddu up to date with the points discussed, the relevant ones being A, and this is where I will stop on that matter, there will be claims for work done actually. There will be claims for work done actually.
Yes, but if you if you look at the document, I'm not very happy with this quotation. It seems to me rather taken out of context. And in context, if you look at 5034,
yes,
what is said seems to be neutral, but we'll have to look at it. Perhaps we can look at it. 5034.
5034.
Volume 13.
Volume 13, yes, Lord.
Now, I mean, this is on cash flow.
Yes.
And we know it fell through. During the construction period, the cash flow should be viewed as a bifocal process. A, the claims for works done actually, and B, the actual schedule of payments. Well, this isn't directed to the question whether this should be whether this is a turnkey or lump sum contract or not.
Or a measure and value contract, William. And this is the point that you are making. You are only paid for works done actually, in our submission, if you have a measure and value method. And this is exactly the point that we were saying. Well, first of all,
however you value it, you're still going to pay according to progress, and that's all it says here. It's not saying we're going to value it on a completely different basis, this contract. We're just saying we're going to pay by stage process.
Can I take your lordship now to paragraph 22.3.2, where this is an exchange between Mr. Juddu and CC. The issue is a matter of the mezzanine floor, and at page 19 of my statement of the case, we see this letter of Mr. Juddu upon a complaint made by CCE about how are we going to be paid for the mezzanine floor, and we see this wording. We are fully aware that the mezzanine floor have been added. We do not see any reason for alarm, as you've been paid on actual work done, irrespective of whether the bill is prepared or not. And this, with all the other letters, which I'm not going to refer to the details to, is in our submission the case which was made by CCE that it was a measure and value contract. We have afterwards the changes to the project. I will not go into the full details of that, except to say that at paragraph 24.4, the arbitrator, in its conclusion, holds that on the issue of whether the design was substantially changed, the version of CCE has not been shaken. It is to the effect that the building has completely changed from the initial project as per the contract, and this inside and outside, from the bottom to the top, the height, the look, the structure, the finish. So this is as far as I shall go, given the time, regarding the changes or the instances where one may seek the common intention of the parties. Now we go to the finance agreement. There's only one thing to say on the finance agreement.
Well, I think you probably need to say very little
Yes.
In view of Ms. Jeffrey's attitude, but what is the one thing you were going to say briefly?
Well, the finance agreement, I wanted to say that in the end, when one sees the minutes of meeting, which was in relation to that, and that's page 37 of my statement of case, paragraph 48.5, where there is this minutes meeting of MSc and CCE, and paragraph 48.5 cites this. In the circumstances, it was considered that the original objective of the finance agreement of the 1st of April 1994, not 1995, this is an error from the letter,
yes,
was potentially achieved, and it had served its purpose.
Thank you.
We're submitting that this, apart from all the chronology that we have put, settles the question of the finance agreement.
Yes.
On the question of the mechanical and electric works, this also can be settled. This section can be settled simply by pointing to your lordship that the minutes of meeting of between CCE and MSc concludes that in fact it was agreed that MSc would pay CCE for any works that was being withdrawn from CCE.
That's loss of profit, is it?
Yes, my lord. That is loss of profit.
But I suppose that wouldn't apply if there was a breach.
Well,
and the arbitrator has.
Yeah.
You need to refer to the arbitrator's findings, don't you? Yeah.
Absolutely, my lord. She don't find anything. It is in fact CCE who suffered damages in the matter because the work was withdrawn from them.
And whose fault it was, isn't it?
And yes, and the claim for loss of profit as well as attendance and profit. And MSc accepted that claim for damages and undertook to pay. This is page 1413, the minutes of the 20th of October 1995, where we read.
So 1413 is, I think, I think we need to look at that.
Yes, my lord. 1413. And when we reach 1413, which is the minutes of the 20th of October 1995,
yes,
your lordship has turned the page to 1414, and there we see at the item 4, Roman 1.
Yes, but what is this talking about?
It's talking about the above items, and the above items are the subcontracted items, 3 Roman 1 to 3 Roman 3.
But this is items according to item 2,
Yes.
on which agreement has been reached with CCE,
Yes.
that they'll be subcontracted.
Subcontract.
Yes. So is it anything to do with the M&E?
Yes, it is to do with M&E, because this is included in what is called the contractor's design portion, CDB, and which is part of the provisional sums.
But where is it included above? I mean,
One should look at the...
which item includes it?
One should look at the provisional sums item to ascertain the list of the items which are included in the contractor's design portion and the provisional sums.
No, you're not helping me. The compensation in 4.1 includes compensation, loss of profit, and all attendances and profit on the above subcontracted
Yes,
items,
my lord.
3.1 to 3.3.
Yeah.
That's balustrades, timber flush,
Yes.
entrance doors, granite and marble lining.
Yes.
Now, you'll have to satisfy me that that's got anything to do with mechanical...
3.1 to 3.3 is the immediately above paragraph, loss of profit.
Sorry,
or
I
attendances.
apologise.
Yes, my lord.
But it's the items in question are listed in paragraph 2. Agreements have been reached with CCE for the following works to be subcontracted by MSC. And
Absolutely.
I think the question that the board is asking, how do we know that the items there listed are relate to, and to what extent do they relate to M&E?
Exactly, yeah.
That is because your Lordship will see that they are being removed from the bills of quantities, and when one goes to the bills of quantities at 555, therefore, if we now go to the bills of quantities, 556, I'm so sorry, my lord, 556,
In bundle 2, yeah.
in bundle 2, your Lordship will see that the provisional sum includes the electrical installation. And that is what we refer to as being the mechanical and electrical works. That's 556 of volume 2, my lord. Your Lordship will see this is the list of the provisional sums. And we see that the provisional sum includes electrical installation. Well, it includes also the aluminum opening, lift installation, etc. But more precisely, the first item is the electric installation. And that is why we submit that the M&E works, included as it is in the provisional sum, were referred to in that minutes.
Where in paragraph 2 do I see a reference to electrical works on page 1413 to 1414?
Yes, yes.
Where do I see it? I simply don't understand the point you're making at the moment. I regret. Maybe my fault.
No, my lord. But what we're saying is this: we're saying that the items which are under the provisional sums are mentioned in this paragraph, which which is referred to in point 3, Roman 1. A loss of profit element is being granted to CCE for all the works removed from the bills of quantities but contracted direct by the client. That is the...
Yes, but isn't that referring to the items listed in the preceding paragraph?
It is.
So that's why I asked you. Go back to paragraph 2, where is electrical works mentioned?
It refers to the bill of quantity. The minutes of proceedings reads that this agreement is reached as being on a loss of profit element being granted for all works removed from the bills of quantities but contracted direct by the client. The reference is all works removed from
I
the
see.
building.
So you say it's not governed by paragraph 2 at all?
No, it's not.
I see. Thank you.
It's not. This
Well,
is the
can
point.
I mean,
Yes.
assuming it's not governed by paragraph 2, bearing in mind that the default in respect of mechanical and electrical works, which the arbitrator attributed to the submission of an unacceptable design by your clients, occurred, according to the arbitrator, by August 1994, it seems very strange that in October 1995 the parties are still discussing retrospectively an agreement to limit any liability or indeed to pay compensation in the opposite direction.
Yeah. Well, this
So,
is.
yes,
My lord, I'm so sorry. Yes.
If you look at the award, they're set out in considerable detail, but the arbitrator doesn't mention the point you're mentioning at all, which would have been a complete answer to the point. Does he? So on the face of it, I mean, it doesn't look as if this document of October is easily connected with anything we're talking about under mechanical and electrical works.
But in our statement of case, we attempt to make it clearer.
You've referred to it,
Yes.
but as far as I can see, it's pulled out of the air. And where is in the award any basis for this submission that page 1414 is the end of the matter? So it would have been a complete answer to it if it had been.
What we're trying to make as a point is that they did not consider it, the not doing of the subcontractors was not being considered as a breach.
Well, you're not only making that point, you're saying they actually agreed to pay compensation
Absolutely.
for something which the arbitrator says was your fault, although inexplicably he then excuses you and says that it was MSC's choice to accept that you've defaulted.
Absolutely. This is the way he places it, and I agree that it's not in the best way possible.
Yeah. Well, is there any other point you want to say on?
Well, the only remaining point is the one of the missing documents.
Well, I don't think you need trouble us on.
But the only thing I wanted to say on that matter.
Well, if you say something on it, there'll be a right of reply, but you understand that.
Yes. Well, in that case, my lord, I don't think I'd make my point any longer than I've made in my statement of case regarding the missing documents, and I think that is all I would have time seeing.
I think
quarter
probably
to 4. Seeing it's a quarter to 4, I'm just saying that.
I think you've come to the end of your allotted time with a little over.
How much about your lordship?
Thank you very much, Mr. Rebo. Is there anything you wish to add, Mr. Rebo?
No, I have nothing to add.
Thank you very much. Yes, Ms. Jefford.
Lord, I hope I will be extremely short. There are only one or two points that I would simply wish to reply on, as much as anything as matters of clarification. The primary point relied upon, both in the arbitration, it's fair to say, and before your lordships, as to conduct evidencing an agreement to vary the terms of the contract would appear to be the payment of the interim valuations. That I suggest is evident from the submissions that Mr. Rebo has just made. In that context, in the submissions he has just made, he relied on the provisions of clause 30 of the JCT contract relating to interim payments, and particularly on the words gross valuation. He gave you a reference at page 1141. I previously took you to the same clause at 4718. I mention it simply for referencing purposes. Without turning it up again, and I think your lordships have the point, the expression gross valuation, where it is used in clause 30.2, is gross in the sense that it is the value of the works being valued on an interim basis before you start making deductions. You make, under clause 30.2, deductions both for the retention monies, that is the percentage held back in effect against the making good of defects in due course, and of the sums previously certified under previous interim certificates. And that gives you a net figure, which is the figure that is payable on the particular interim certificate. That is the manner in which the word gross is used in that clause. I can't really make that submission any better by reference to authority.
No,
it's simply what the clause says.
It's simply what it says, that the gross valuation as referred to in 30.2 less the two factors you mentioned.
Indeed, yes. And the point, and I will, I'm afraid, be repeating myself if I take this any further, the point about the interim valuation, as I have said, and I appreciate that you may accuse me of giving evidence in this respect, is that it doesn't matter. There are different ways that you might value on an interim basis. It might be measure and value, it might be percentage. But the fact that an interim valuation is carried out in that way, or in a different way, and paid under the contract, doesn't in and of itself, cannot in and of itself, amount to evidence that the parties have agreed to change the terms of the contract in respect of the final amount payable, that is the contract sum as adjusted. And I've dealt with that point in the appellant's case at paragraphs 56 to 59, and I simply rely on what I have said there. In relation to the evidence of Mr. Jadoo, in respect of which there was a specific question, the transcript, I believe I mentioned this morning in a different context, but there was agreement between what happened in the course of this arbitration. Mr. Sozier, Mr. Rebo were there, I wasn't, but we have the transcripts up to a point, was that there was lengthy examination in chief of Mr. Jing from CCE over a number of days spread out over a number of months. And then Mr. Sozier began his cross-examination of Mr. Jing, which also went on for some time. And there came a point at which there was an agreement before the arbitrator that there would, with limited exceptions, be no further oral evidence and cross-examination.
Otherwise, one suspects the case would still be going on.
Well, that's always possible, my lord. And the upshot was that the balance of Mr. Jing's evidence was given in writing, and the evidence of other witnesses for both CCE and MSC was given in writing. The agreement was, as I think I mentioned, that the parties would be sworn. Oh, I'm sorry, not the parties. The witnesses would be sworn, but there would not be cross-examination. However, the lack of cross-examination was not to be taken as acceptance of the evidence, and the evidence could still be the subject of comment. And so, in effect, what happened was that there was comment on the respective elements of evidence. And in the case of Mr. Jadoo, he did indeed attend to swear his statement. That is at page 124 of the bundle in volume 1, I would imagine. There was some examination in chief because there was a misreference by Mr. Jadoo to the name of the standard form contract, which was corrected. And then at the conclusion of what he had to say, this is page 126, Monsieur Sozier said, "We have agreed that the witnesses will only swear to the correctness of their documents."
Yes, well,
Mr. Rebo agreed.
Got that, yes.
And then there was a question, do you propose to cross? And Mr. Sozier said no, on the basis that, and it was made clear that failure to cross-examine didn't amount to admission. So that was the position on challenge to Mr. Jadoo's evidence in the sense of cross-examination. In the report provided by Mr. Bowler, which MSC relied on as its evidence as to proper valuation, the key issue wasn't so much the valuation of the interim certificates, but the valuation of the final account for the reasons that I have explained. Finally, my lords, I would not wish it to be thought, because I did not make further oral submissions in relation to the financing matter, that was to be taken as some acceptance of the respondent's position on the financing matter. It was simply that, in the light of the respondent's case, it didn't seem to me, with the time constraints this morning, that I could add very much usefully in respect of the appellant's case. All I would say...
Maybe I should give Mr. Rebo a chance to say anything he wants to then on that, in that light.
Perhaps, it was simply your lordship made the comment about perhaps you didn't need to deal with it.
What is the issue? I had understood you to be taking on board the fact that the objective of the finance agreement had been achieved.
Well, no,
that
Lord,
was the end of the matter. But
That's how I understood it too.
No, that was a point that had always been made. That wasn't a new point from the respondent's case. It's not perhaps the most elegant part of the arbitrator's award that deals with this issue, but if you look at his award, it starts to deal with this question at page 456 in volume 1. Thank you.
Probably, yes.
You will have gathered, my lords, that I never got the volume references. I apologise, but we've just about kept up. He starts to deal with the financing agreement at that point, and there is... I think the best I can do perhaps is to ask your lordships to read in due course through that section, concluding on page 465. There is, to say the least, some degree of lack of clarity in the award as to whether there was an initial agreement in December 1993 to include financing within the contract and within the 100 million rupees figure. But there was clearly an agreement to that effect by virtue of the agreement signed on the 1st of April 1994, which is the one with the payment schedule in that we looked at previously.
That must supersede it, mustn't it?
It must have done, yes.
Yep.
And there was no doubt that was a binding agreement.
Yes, and it wasn't performed either side.
And it wasn't performed, no, it wasn't performed on either side. And then...
So why wasn't that tacitly dropped?
Well, but Lord, I rely in this sense on or in this context, on the decision of the arbitrator himself, and that's the basis on which this appeal is put. If you continue to page 464, what he says is that CCE requested the cancellation of the finance agreement, but the request was never acceded to. That's 6.8.1. Then at 6.8.2, he says he records the fact that Mr. Ajuda said the objective of the financing agreement was potentially achieved and it had served its purpose. And then at 6.8.3, which the respondents do not quote in their case, CCE may have been in breach of the above agreement. However, here again, the breach was accepted by MSC and the contract was to that extent varied with a tacit agreement of both parties. So my submission, read in context, that is another instance where the arbitrator finds that there was a breach. I appreciate he uses the word may, but in context it clearly means, well, there was a breach, but it doesn't matter because somehow MSC accepted that and went along with it.
But and what's the loss? What's the claim here?
This is, I'm sorry, I'll put the grounds of appeal to one side again. I'll try to answer the previous question. It's, I think, in the region of 13 million, I'm sorry.
How does that arrive?
It is interest and bank charges incurred by MSC in obtaining bank funding elsewhere, which obviously was covered in factual terms in the course of their evidence in the arbitration. And the basis, well, the basis that I say, well, that he obviously found there was a breach, and then for some strange reason thought that somehow it had been waived or accepted, is made clear from paragraph 6.8.7 of the award on page 465, where he says, even assuming there had been an agreement to finance the project, well, there clearly was one, and a breach of such agreement, MSC had eminently condoned and accepted such alleged breach and not relied upon it to consider the contract as at an end and to rescind it to such an extent that the only reasonable inference to be drawn from the parties' performance of their respective obligations thereunder is that the initial financing agreement, and it's not clear what that refers to, but it appears to be the first one, not the modified one, was modified and varied with the mutual accord and agreement of the two parties. So there is a rather curious bit of reasoning to the effect that because MSC didn't bring the contract to an end when it didn't receive its financing, that it is to be taken to have acceded to the breach. My Lord, those points are dealt with in the appellant's written case. It didn't seem to me that the reference to Mr. Ajuda's comment in a meeting that the financing agreement had potentially been achieved, cut through that, not least because it is referred to by the arbitrator in the award. And I didn't, as I say, think there was anything, I'm not sure there still is anything I can usefully add to the appellant's written case, but I'm anxious that your Lordship shouldn't think that that case has somehow been abandoned by my not.
So how was it going to work? The cash flow was going to involve, just looking at the agreement,
yes.
It was going to involve what, CCE giving your sums, your clients an advance payment by way of effectively interest-free loan.
Effectively, or by not receiving payment, so that it would in effect be an interest-free loan.
And you say you had to go elsewhere. Just you say it's in the note. You say it's in the notice of appeal somewhere. How you calculate
It's ground 5 in the notice of appeal.
But that just gives us a figure. It doesn't tell us how you get to it, does it? You see
I'm sorry, my Lord. The figure is 13,720,000.
No, but where do we find that?
6079, it's in the notice of appeal at the end, grounds of appeal.
Yes.
You had to get 57 million rupees elsewhere and incurred 13 million
in interest and other charges. Well, that was the subject matter of.
Which page was it?
6079 but it's in the notice of appeal which we got separately.
Which is, yes, which paragraph?
It's right at the end.
Yes, correct. Yeah, I've got that.
What are you saying we're meant to do with this? We're meant to.
Yeah, I know what the amount is. Is that the breakdown?
We want us to review the findings of fact on this, do you?
It's one of those questions on that borderline between is it fact or is it law? Because the arbitrator appears to have found as a fact there was an agreement which was not complied with. But
that was effectively condoned. Well,
but somehow condoned. Now, I would say that absent any, not dissimilarly to the other issues that have troubled your Lordships today, not dissimilarly to those matters, there is absolutely no evidence for that conclusion other than the, frankly, rather curious reasoning that because MSC didn't terminate the contract or rescind it, is the arbitrator's terminology, for that breach, that they have somehow accepted, I put that word in quotation marks, the breach in a sense that means it could not sound in damages. I would suggest that that is an issue of law, not an issue of fact. And if he's wrong about that in law, then...
We have to find out what actually happened. I mean, there clearly was discussion of this issue. We've seen that.
Yes, yes.
Where it was said someone suggested it had been effectively overtaken by events. You say that was never agreed. But what evidently happened was that your clients did go elsewhere, did get the money.
They got the money somewhere else.
Whether at some point, I mean, did they at some point say to CCE, well, look, we're running up these enormous charges from our bank, you better get on and comply with the agreement? Or, I mean,
so when's the claim?
The reference I have, volume 13, page 5051, excuse me, the claim is obviously within the MSC statement of claim, but the breakdown of the figure is at 5051.
Yes, well, this is some time after. This is November 1998.
Yes. Well, this is
I
when
think
the
my lord
parties
is-
are in dispute.
My lord was perhaps looking for some complaint during the running of the contract.
Other than the matters that are recited by the arbitrator, there's nothing I can expressly draw Your Lordship's attention to.
And can we look at this particular issue in isolation? The arbitrator will have heard the whole evidence. He will have seen that there was wholesale departure from the terms of the agreement, or certainly from the initial bills as to what was built, as Mr. Jadot makes very clear at page 690. And he had to infer whether or not the parties had agreed in this case, as in others, to do things differently. I mean, on what legal basis can we overturn his conclusion that this was a matter that the parties had agreed to live with?
Lord, if Your Lordships are persuaded that that's a factual issue and was entirely a matter for the arbitrator, unless it's obviously wrong, then I'm not going to seek to persuade you otherwise. But the basis on which the appeal is put is that
I should analyse the legal issue.
Exactly. If you actually read what he has said in his award, it makes no sense legally, whatever the facts may be.
Thank you.
I don't think there is any normal or
Well, we better give Mr. Rebo a chance to say anything he wants.
Thank you, my lord, but I'm not very sure whether I have anything to add, except pointing out that the reference to this financing issue has now must be put to rest because it has been potentially achieved. Now, this, in my submission, means what it means, and nothing more than that.
What do they mean by it was potentially achieved? I mean, it wasn't achieved at all.
Well, the respondent thinks that nothing was achieved because the only thing that could have been done under that finance agreement of the 1st of April 1994 was that the monies obtained from the sale of the apartments, units, spaces in the construction, that money would serve as a cash flow to pay the contractor. And the only thing the contractor had to do is continue constructing, but expect not to be getting exactly the value of its construction, but as and when the cash flow schedule concerning the sale of the units and spaces would provide.
Yes.
That, I think, is what the finance agreement says. Now, whether it was achieved completely, whether it was achieved partially, in my submission, this writing at the minutes of meeting saying we think it's potentially achieved, whatever that may mean, settles the matter of the financing. This is all I would like to but I've already said that just before my learned friend stood up to ask.
Thank you.
I'm much obliged to you.
Thank you very much. Ms. Jefford?
Nothing further.
Thank you much. The board is grateful to counsel and those behind them for the preparation and submissions, and will take time to consider its judgment.
Ooh.